Laws relating to accessibility. Chapter 1, the Americans with Disabilities Act, usually referred to as the ADA. This training video is produced by the Accessibility and Policy Unit of the California Department of Social Services. This chapter provides an overview of the ADA and how it impacts our work at the California Department of Social Services. First, here is some basic information about the ADA. Modeled after the Civil Rights Act of 1964, the ADA is an equal opportunity law for people with disabilities. It was signed into law on July 26, 1990, by President George H.W. Bush. The ADA prohibits discrimination and guarantees that people with disabilities have the same opportunities as everyone else to participate in the mainstream of American life, such as enjoying employment opportunities, purchasing goods and services, and participating in state and local government programs and services. It should be noted, the ADA does not invalidate other laws, including state laws that provide greater protection to individuals with disabilities. It does, however, encourage both parties to seek alternative methods of resolutions, rather than lawsuits. Speaking of lawsuits, one very big reason to ensure our department remains in compliance with the ADA, and other laws addressing accessibility, is to avoid costly civil litigation. Many states, counties, municipalities and state departments have been sued for failing to comply with the ADA, resulting in large financial penalties. Financial penalties would take valuable resources away from our mission. In the long run, our clients, the very people we are all here to serve, would pay the actual price, in the form of diminished programs and services. But even more important than adhering to the ADA to avoid lawsuits, is following the requirements of the ADA so that we provide equal access to both fellow employees, as well as to our clients and stakeholders. We adhere to the requirements of the ADA because it is the right thing to do. Now we will discuss what the ADA covers, who is provided protection under the ADA, and finally, some resources to ensure compliance. Let's take a closer look at what the ADA covers. The ADA is divided into 5 titles. Title 1 covers employment and provides protections from discrimination against qualified individuals with disabilities. These protections cover job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. The ADA covers employers with 15 or more employees, including state and local governments. It also applies to employment agencies and to labor organizations. Title II covers public entities such as state and local government entities, and transportation services administered by these entities. This video will cover the Title I and Title II requirements of the ADA in more detail a little bit later on. Title III covers places of public accommodations and commercial facilities. This would include private sector entities with whom we contract services. Title IV covers telecommunication services, such as phone companies that are required to provide telecommunication access for persons with hearing and speech disabilities, including telephone relay services. In addition, television stations are required to provide closed captioning for public services announcements and emergency notifications. Finally, Title V of the ADA is entitled Miscellaneous. This section contains definitions of the terms used by the ADA and provides timelines for implementation. Title V also allows states to be sued under the ADA, permits payment of attorney/expert witness fees, and prohibits coercion and retaliation. Now we will focus primarily on the ADA requirements under Title I and Part 1 of Title II that apply directly to our work at the California Department of Social Services. Titles I and II of the ADA prohibit discrimination against qualified individuals with disabilities in employment, programs, activities, and services. These requirements apply to all state and local governments, their departments and agencies, and any other instrumentalities or special purpose districts of state or local governments. These titles also outline the administrative processes to be followed, including requirements for self-evaluation and planning. They also include requirements for making reasonable modifications to policies, practices, and procedures where necessary to avoid discrimination. Title II also requires architectural barriers to be identified, and to ensure effective communication with people with hearing, vision and speech disabilities. Adherence to the requirements of Title I are enforced by the U.S. Equal Employment Opportunity Commission, while the requirements of Title II are enforced by the U.S. Department of Justice. Now that we know a little bit about what the ADA covers, let's define more specifically who it protects. The ADA protects persons who are qualified to do a job, as well as those eligible to participate in a given program or activity, with or without modification, from discrimination on the basis of their disability. So who has a disability? 1 in 5 Californians report having a disability, and over 10% of all state employees report having a disability. In fact, almost 11% of Department of Social Service employees report having a disability. Some people are born with a disability, but acquiring a disability, either permanently or temporarily, is either a normal part of the aging process or can result from an unexpected accident or illness. So what is the definition of a disability under the ADA? The ADA defines 3 groups of people for whom it provides protection. The first group protected are persons with a physical, mental or medical impairment that substantially limits one or more major life activity, or MLA. Major life activities include walking, lifting, performing manual tasks, sitting, breathing, speaking, hearing, learning, reading, personal care/grooming and other daily activities. A person is considered substantially limited in performing a major life activity if they have some type of physical, mental or medical impairment that significantly restricts the manner, duration or ability to perform a major life activity when compared to the average person in the population. The second group of individuals protected by the ADA are individuals with a history of, or a record of an impairment who are discriminated against on the basis of their previous condition, such as a person with a history of alcoholism or a back injury. If they have recovered, but are being treated as if they still have that condition, this would be discrimination. The third group involves individuals who are improperly regarded as having a disability. This would include someone who does not have an impairment that substantially limits a major life activity but nonetheless is treated as if they do. Additionally, the ADA also protects individuals discriminated against on the basis of their association with someone with a disability or someone who is retaliated against because they requested an accommodation from the employer. Now that we know a little more about the ADA definition of a person with a disability and who is protected, let's talk about the employment provisions under Title I. Under the Title I employment provisions of the ADA, no employers shall discriminate against any qualified person with a disability in regard to any aspect of employment. A qualified person is an individual who, 1. satisfies the requisite skills, experience, education and other job-related requirements of the position, and 2. can perform the essential functions of the job, with or without reasonable accommodation. A reasonable accommodation is any change or adjustment to the job, the work environment or the way work is customarily done which permits a qualified applicant or employee with a disability to perform the essential functions. A no-tech accommodation costs little or no money, just time, support and creativity, for example, additional time for testing on an exam or a flexible work schedule. A low-tech accommodation is any accommodation that is technologically simple or unsophisticated, and readily available in most offices, such as a door handle as opposed to a doorknob, to accommodate an individual with limited grip strength in their hands. A high-tech accommodation is any accommodation that uses advanced or sophisticated devices, for example, screen reading software with synthesized speech. The ADA requires employer to make a case-by-case determination of each and every request. An accommodation can be anything needed to allow a person with any type of protected disability to perform his/her essential functions of a specific job. To reiterate, an accommodation can be any change to the workplace or the manner in which the job is performed that will allow a qualified person with a disability to perform the essential job functions or enjoy other workplace privileges. Please note the ADA does not require employers to implement an accommodation that imposes an undue hardship on their business operation. Nor are employers required to eliminate job duties or change supervisors as an accommodation. For questions about a reasonable accommodation for either a current employee or job applicant, you should contact the Reasonable Accommodation Unit. Now let's quickly review how the ADA, as well as California Government Code 11,135, protects the clients and stakeholders of our programs and services. In essence, they say, No person shall be unlawfully denied full and equal access to the benefits of any program or activity that is conducted, operated, or administered by the state or by any agency funded by the state, or which receives financial assistance from the state. It is important to remember that the legal obligations set forth in the ADA apply not only to our department, but also to any organization, group or other entity we contract with for the delivery of our program services. All Californians, including those with disabilities, their families and our strategic partners dedicated to meeting their needs, rely on our department's compliance with the ADA to ensure their full participation. For more information regarding the ADA or how to ensure we remain in compliance, contact the ADA coordinator located within the Accessibility and Policy Unit. For concerns or questions about how an outside entity or partner agency is following the rules and protections established by the ADA while delivering our services to clients, contact the Civil Rights Bureau. For questions or more information about reasonable accommodations for yourself, an employee or applicant, contact the Reasonable Accommodation Unit. Remember, the ADA is a civil rights law which ensures equal access for all Californians. Compliance with the ADA is the responsibility of all California Department of Social Service employees and is a requirement to ensure the department meets our mission and objectives. For more information about this topic, or any of the topics in our series, contact the Accessibility and Policy Unit at accessibilitypolicyunit@dss.ca.gov.